You're outside the Royal Courts of Justice with Andrew Bridgen, and you're about to go in for your case against Matt Hancock. How are you feeling?
I'm as confident as you can be. My counsel, Chris Newman of the New Litigation, has created a very good, very strong, skeletal argument. The facts of the case are we're here today because Hancock wants to strike out my application again. He's making what I would regard as the preposterous claim that his tweet alleging that I'm anti-Semitic has done me no harm. I'm going with a defence of that, and also that the harm is so strong and can be demonstrated. Plus, we will demonstrate today that after 2 years of litigation, Matt Hancock has been unable to produce a legal defence. That's why we're here today. He's not gone with a defence of truth, which means that he has to accept, in legal terms, that what he tweeted in response to my tweet, alleging that I was anti-Semitic, is false. But he chooses in his defence to try and assert that it could be true, which is rather, as my barrister will put it, rather like a man pleading guilty in front of the court, and then when it comes to sentencing, claiming, well, actually, I'm innocent. You need to take that into account. You can't have your cake and eat it. And this is despite Hancock having access to the finest legal advice on defamation in the country. If he can't create a legal defence after 2 years, I think the reason is he's incapable of creating a legal defence, in which case we ask the court today, if they agree with our arguments, for summary judgment and award the case to me overall.
So Matt Hancock's attempt to strike it, is that the reason why you were having to front a lot of the legal bills for this?
Yes, we were due to have a CMC, which is a case management hearing, on the 26th of November last year. Just before that, this application came in. What he's always thinking to do is to delay, increase the costs, because clearly he's got access to a lot more backers and money than I have. And that is a common tactic, unfortunately, in litigation, when you're litigating against someone who's got a lot more money than you have. All they want to do is delay and run up the costs. But hopefully there'll be a watershed moment today.
So I saw the original tweet that Matt Hancock claims that you were anti-Semitic in, and you were actually quoting someone else. In hindsight, would you have still tweeted it or not?
Well, the law is clear. You retweet someone's tweet, you own it. It's yours, so that doesn't make any difference. Well, what I actually said was that the rollout of as a leading cardiologist told me, the rollout of the COVID-19 vaccines is the biggest crime against humanity since the Holocaust. And the important word is since. There's a clear definition of anti-Semitism, which is it's to deny the Holocaust or belittle the Holocaust. Well, saying that the COVID-19 vaccine rollout was very bad and is the worst thing since the Holocaust, so it's not as bad as the Holocaust, it's not diminishing the Holocaust, it's not denying the Holocaust. Hancock and Sunak, for that sake, know exactly what the definition is a legal definition of anti-Semitism. That tweet doesn't reach it. That's why they never went for a defence of truth. That's why they're stuck with falsity. But what Hancock wants to do is try and have both worlds. He knows he can't defend anti-Semitism, but he wants to indicate perhaps he could have done if he decided to. Well, that isn't the way the law works. And what's interesting is that the book we got all this from, to learn all this as a litigant in person, was written by Aidan Earley, who's Matt Hancock's lawyer. So he knows darn well. I do hope that Mr. Newman will be showing the book in court today. So there's no way that Aidan Earley didn't know what he was doing. He's tried to pull sharp practice, should we say, and that, for a man who is a Casey and has just been made up to a judge on the King's Bench, the very bench that we'll be on today, I think that could well be a matter for the Bar Council to have a look at that sort of conduct. Or he's completely incompetent.
What do you think Matt Hancock's motivations were for making the comments against your tweet?
Well, he's admitted that his tweet is defamatory. He's he's admitted that he had a vested interest in maintaining the government's line on safe and effective and the vaccines, which is clear, as a former health minister who bought them in. I believe that his whole, since he knew, he's never said it was true in court, he's never admitted, gone with the defence of the truth, he's not a stupid man. He knew when he started that it wasn't anti-Semitic. What he was looking for actually is exactly why we're here today. He was looking to damage me. Also, he's admitted it's defamatory, and it's not true, but he's refused twice in 2 years to take it down. Now, if you knew the tweet was defamatory and you knew it wasn't true, and you would have thought now you would take it down. Well, he refuses to. And in fact, he's retweeted that he has no intention, because he stands by his statement that it's anti-Semitic. So he's actually flying in the face of his own evidence, which again will be brought out in court today. He wanted to harm me. He wanted to get me cancelled. He wanted me out of Parliament. He wanted to dissuade other MPs from speaking about their concerns about the safety and efficacy of the vaccine. And to a great extent, he has succeeded in many things. But we'll see if he succeeds in the Royal Courts of Justice today. It's going to be fascinating. So we will see where it goes from here. But I'm clear, we stand on the law. If after 2 years Mr. Hancock, despite having access to the very finest legal minds in defamation, can't get a legal defence, the reason for that is he has no legal defence, and this case should be awarded to me. And what's been very worrying as well is that it would appear that Mr. Hancock's been shopping for judges for this case. Back in November, he suggested he wanted Judge Nicklin to sit on this case. Though we've actually got Mrs. Justice Collins Rice, but he wanted Judge Nicklin. Now, I would remind your viewers that Nicklin is the judge who put the contempt order on Tommy Robinson, and I'd also point out to you that Mr. Hancock's barrister, KC, Aidan Eardley, is the KC that the Attorney General selected to prosecute Tommy Robinson and put him in prison. So you're looking, he tried to bring a team together, I would suspect, that have a relationship. Anyway, I said that I wasn't going to have that because I've been on television very critical of the judge's decision in the case of Tommy Robinson. That was seen by millions of people, and obviously we wouldn't want the impression of possible bias, would we?
How do you feel about all the public support you have to win this case?
Oh, the support from the public. I wouldn't be here today without the support of the public. They crowdfunded the case for me. I couldn't have afforded to be here, and that's the problem in this country. They've taken justice to make it so expensive that most people just can't afford to get justice, even when you've got a very strong case. In speaking out about the vaccines, I apparently lost a lot of friends. I thought they were friends in the House of Commons and in the Conservative Party. But I've made a lot more new friends, and they're genuine friends who stand with me. The answer is you speak your truth, see who hangs around you, found your tribe. Well, I've found my tribe, haven't I? So we are here outside the Royal Courts of Justice after the court case between Bridgen versus Hancock. How do you think that went? I think my barrister, Chris Newman, I think he did an excellent job. And obviously judgment is reserved, so Mrs. Justice Collins Rice will now cogitate and read. I think she's going to struggle to be able to strike out our application. I think it clearly has merit, as demonstrated by Mr. Newman's submissions, and it's in the public interest for it to move forward. And time is not with Mr. Hancock, because as time has moved on in this case, and he's deliberately delayed and tried to stop it getting to final hearing. I can tell you now, Matt Hancock does not want to be cross-examined over his part in the pandemic response to the vaccines. He doesn't want to see that evidence. That is why he's never put in a witness statement signed by himself. so that he can never be cross-examined on anything. Because I believe that if were he to do that and put a signed witness statement in, he would be at risk of being held in future for what he said, either as when the COVID-19 vaccines are suspended, which I believe will be in the next few months in America, pending a full investigation, the same vaccines that we took in this country and the rest of the world, and any witness statement he signs will be held over him in future, and he doesn't want that because he knows the facts. And the facts are as well that the number of times I asked while I was in Parliament to sort this issue of vaccine safety and efficacy out once and for all, release the record level data anonymised that the government holds, data that's already been given to the big pharma companies who've inflicted these very harmful vaccines, so-called vaccines, upon the public. And the government would have been very easy for them to clear all this matter up, establish the safety and efficacy, release them. And the fact is that Robert Kennedy Jr. and Jay Bhattacharya, two excellent people I'm acquainted with who are now in positions of responsibility in America, they have now got access, undoubtedly, to the American record level data, and they will have to suspend these dangerous so-called COVID-19 mRNA platform vaccines very, very soon, or merely by having that data and not acting on it, they will actually become an accomplice to what has already been perpetrated against the people, and they won't want to do that, and they shouldn't do that. So I think we're going to see, if the case moves forward, the facts are going to be coming out, and it's going to be looking increasingly bleak for the prospects for Matt Hancock.
There seemed to be an ever so slight tone of Holocaust denial from Hancock's brief. What do you have to say about that?
Yes, at the end he read out something from I think it was Ms. Pollock, who was at one of the Jewish jeopardies. Yeah, and I sat next to that very lady at the Conservative Friends of Israel dinner only a week or so before the incident where I was accused of being anti-Semitic. They can wheel her out from CCHQ to say anything she wants to, and they will have done. And all this stuff about Hancock, Sunak, that will have all have been coordinated through CCHQ. That's how they will have done the smear. And of course, we moved forward to final hearing. We should ask for disclosure, and it will become apparent that it was a conspiracy to damage me, coordinated either by Number 10, by Hancock himself, or by Conservative Central Office, probably all three.
Because they've been reiterating the same points, is that abuse of the process, and will you be searching for any consequences for that?
I think they have actually abused the process all the way through. You can see what they've done is they've elected not to claim truth, which would have had to have been fought out in court. Then there would have been a hearing over, is the tweet I put out anti-Semitic, and it clearly is not. So he knew that. He knew he wouldn't win that, so he chooses not to contest that. And we saw that on so many of the issues we've seen today. But then he wants to insinuate that it is, as my barrister said in court, it's like someone pleading guilty, and then when it gets to the sentencing stage saying, but Judge, you've got to remember, I know I pleaded guilty, but I'm actually innocent. And it just doesn't work like that. Hancock's team appear to want to twist the rules to suit themselves. No one's above the law, not even former cabinet ministers or prime ministers, I believe. And that is really where we are now with this case. I think there's huge public interest in it. I'm hoping that Judge Rice, Collins Rice, will find for us, and history's not going to be kind on Mr. Hancock, unfortunately.
Do you think that the courts are legitimate enough to reach an honest verdict and actually put it out?
Throughout the hearings we've had at the Royal Court of Justice and the proceedings and the letters that I've written to the court, I have detected a very serious bias towards Mr. Hancock's representatives. And if you want examples of that, I mean, Aidan Eardley, who you saw today, He's actually been made up to a judge on the same bench as the judge sitting in judgment on us today. Now, that doesn't seem quite fair to me. Now, Hancock himself tried to shop for the judge for the case today. He wanted and suggested he wanted Judge Nicklin. And Aidan Eardley, who you saw today, Hancock's barrister, KC, he is the barrister selected by the Labour Attorney General who sent Tommy Robinson to prison for 18 months for contempt of court. One could say that he was fishing for a judge who owed a favour to a barrister who put someone away who potentially was releasing evidence that was questioning his probity. That's quite a tight link. When I've tried to keep the CMC in play in November, the court had decided to cancel it until I pointed out to them here, you can't cancel the CMC because an application has been made by Hancock's team for another strikeout, because no one's applied to you to cancel the CMC. You can't just unilaterally cancel it. 3 hours after I wrote that email to this court, there was an application from the other side with no corresponding email back to me, another application from the other side applying to cancel the CMC, the case management hearing. How did they know unless the court had been in touch with them? And also, we've caught judges responding in judgment with correspondence. As I said, Mr. Eardley has been made up to be a judge on the same bench, there, Hancock's KC. Obviously, in this case, he always emails them as RPC, Hancock's legal team. I only have Mr. Newman. In response, the judge used Aidan Eardley's judge email, something she'd never received through these proceedings. And it clearly, when she went onto her Outlook or whatever, her Google Mail, that was the one that came up most often. The one that, when she put his name in, his judge email came up, which has never been used in these proceedings. And she sent an email to his judge email in response in these proceedings. That means that clearly Mr. Eardley and the judge have been in private correspondence on a judge-to-judge basis outside of this case. I don't think that's very fair, do you?
No, I think that you would have definitely been pulled up on it if someone who
and another thing, when I oppose the CMC being delayed, being cancelled, because that's basically delayed the case for another 6 months, probably 12 months. That's why we're 2 years in and we're nowhere near getting to a final hearing, because Hancock doesn't want a final hearing. And when I objected to that, it was a Thursday evening, and the judge gave me till Monday morning at 10:30 to get my reasons in. I had to work with my barrister over the whole of Remembrance Weekend to get that paperwork in, which was rejected by the court. But the rules are that you're supposed to have a minimum of 3 clear working days, not weekends. The court only gave me 1. And when I wrote to them, I said, why are you only giving me 1 day when the rules are you have to give me 3 clear working days? Again, just like the shopping for judges, just like the emails, and there was no answer.
Hancock's brief, I could see his hands were visibly shaking. And I think your brief...
And also he was talking rather quietly, which I think is something you tend to do when you're neither confident or confident of your arguments.
Do you think that it's Matt Hancock's task to bleed you dry of money with all these court case proceedings?
Absolutely. That is the normal tactic now in this country. Litigation is very expensive, and it's very, very hard to take anyone to court who's got more access to more money than you, because all they do is delay, run the costs up till you run out of money, and that makes a mockery of justice.
So where can people find you and how can they support you?
They can find me at I'll give you a link to the fundraiser, so you can put it out there for the fundraiser for the legal costs. Okay?
Cool.
Thank you.
Thank you.
Thank you.